In May of 2022, Sabrina Borg was arrested and accused of aiding a murder. She spent 2.5 years in a San Francisco city jail waiting for her case to be presented. When she appeared before a judge in November of 2022, the case was dismissed for a lack of evidence. If her case could be examined on time, she wouldn't have wasted over 2 years of her life in jail. In more than a dozen American cities, pending criminal cases jumped from 380,000 in 2019 to 550,000 in 2021. The number of pending cases in 2021 totaled nearly 1.3 million. In several cases, representation at initial hearings significantly increases the number of defendants released on their reconnaissance. Additionally, 2.5 times as many represented defendants had their bail reduced to an affordable amount as compared to unrepresented defendants. Nearly 2/3 of jailed persons in the U.S. have not been convicted, but are in jail because they cannot afford bail and must be held until their court date. Their cases are often sent to state public defending offices, adding to the already overwhelming caseloads. Increased funding will enable public defenders to represent indigent defendants at initial appearances, which will improve the quality of representation public defenders can provide. Proper funding will additionally negate the need to establish any new agencies that the state government will have to fund. This strategy provides indigent defendants with their own constitutionally protected Sixth Amendment rights. Judges that handle unusually large caseloads often have been assigned the responsibility of handling multi-district legislation. Here, similar cases from more than one district are bundled together and assigned to a single judge, to rule on and conclude based on a category. United States District Judge Joseph Robert Goodwin closed the most cases in the nation last year, a record of 40,500. He also continues to have the largest pending caseload of 25,000 civil matters still pending. This extraordinarily high workload was because he was assigned the responsibility of handling multi-district pelvic repair system product liability legislation.
Under federal law, all sitting district court judges must be nominated by the president and then authorized by Congress to operate in a specific district, so court administrators can't simply move judges from less occupied districts to more occupied. The Chief Justice, John Roberts, has stated that he's worried about the imbalance between the increasing flow of cases submitted to the courts and the number of operating judges and staff has furthermore been a concern for numerous years. Roberts has also stated that politicians pushed for increased prosecution during the war on drugs, and now they're pushing for the prosecution of undocumented immigrants, even though there are solely around 870 authorized Article 3 federal judgeships. The way to alleviate heavy caseloads is to delegate them to more people. Diverting public drunkenness cases, traffic violations, drug possession cases, and such from major trial courts to special courts can shrink caseloads. It can also help nonviolent first-time offenders so that they can be issued a fine. As cited by CliffNotes.com, the overworked lower courts can be aided by removing civil disputes to mediation. Public-private disagreements between spouses, neighbors, and associates clog the courts. As cited by uscourts.gov, this strain was spurred on by tougher drug laws, and court cases have been steadily increasing. Around 2/3 of the state-level courts are considered constantly behind on their dockets. Caseloads affect their personal bias. This practice is extremely common, at least in New York, where it can be seen from a vantage point of public defenders' offices. Equal access to justice requires vigilance to prevent assumptions from obscuring facts. For example, the factoring of the socioeconomic status of the accused for ruling against them in the caseloads, meaning that one case could be quicker solved because the person has bailed compared to the other one who doesn't. People who feel alienated from the dominant culture often perceive that they will not get a fair hearing because they fear their circumstances will get them a ruling against them because their case is faster to solve.
Caseloads are when various factors in a case are monitored and measured to estimate the time/resources needed to close that case. Case weighing systems have a wide variety of practical applications. They can be used to determine the total number of judicial officers locally and across the board required to efficiently and effectively handle the workload of courts. Also to aid in the process of redrawing judicial boundaries and assess the resources required to clear court backlogs. Case weights may be created on the basis of expert opinion or a time study. and are designed to incorporate sufficient time for quality judicial decision-making. These systems can be used to determine the judicial resources needed to eliminate a backlog of cases, calculating the amount of work associated with the total excess pending cases, and the use of a number of temporary resources. This allows courts to delegate workloads more evenly. These seemingly solve the whole issue, but the strategy requires accurate and precise data that is difficult to collect. Requiring data on how many cases of each type are filled with each court. It's difficult to say the least.
So, in conclusion, there are multiple ways that judges could eliminate their overworked court caseloads. Some of the solutions being redirecting minor cases from major trial courts to special courts, removing private civil disputes to mediation, integrating weighted cases, and by hiring more judges.